Lawyer. Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It's Tuesday, which means we're doing our Tuesday night live show. Thanks for joining us. Now, you know the drill. Subscribe if you haven't, like if you do. Leave me a comment below and hit that little bell for notifications. All right. Now, it is Tuesday night, which means that, well, it's your show. We'll try to take your questions, and we're probably going to put up the call-in line as well so that you can give us a call and talk about the cases that you want to talk about. Now, full disclosure, last week we didn't do any shows except one, I think, on Thursday because I was in trial. And for those that did watch on my show on Thursday, you know, we lost. I know. It sucks losing. I hate losing more than I like winning. But sometimes those are the facts that the client deals you. And you do it the best you can with what you've got to work with. But pro point, like I mentioned last week, let it be known, we are not encouraging anyone to commit violence against anybody. That is an absolute no-no. Don't do that. But let's say hypothetically you're in a situation where you think you got to do it. Pro point number one, check for video cameras. Okay. Two, if you think you still need to proceed and you're looking for self-defense, another pro tip here, don't pursue the person with no weapon and then shoot them in the back. All right. Not being judgmental, you know, the heat of the moment, you got to do what you got to do. But the reality of it is that, the reality of it is juries don't always see that as, well, self-defense, right? Were you in fear of death or serious bodily injury? Yes. Now, there's no duty to retreat, but it's also kind of frowned upon that you not chase somebody down and then shoot them in the back. Just saying how it is. All right, ladies and gentlemen. Now, remember, you know, a good case like self-defense, we've talked about this before, is that, you know, most cases, the defense is identity. I didn't do it, right? They have to prove that it was the defendant, not somebody looked like the defendant, not somebody using the defendant's identity, but it was, in fact, the defendant. Identity. That's usually to the defense. But an affirmative defense is you're saying, you know what? I did it. I'm going to own it. And I think I was legally excused to do so under the law. And then the jury decides whether it was reasonable or not. So take that for what it's worth. I'm giving Frank, the hardest working man in show business, the signal that the food has arrived. Of course, it arrived after we started the show. So Frank will be able to eat. I will not eat anything until after the show, but that's all right. You can, that's just the way it is. So like I said, that is the affirmative defense, right? There aren't that many affirmative defenses under the law, right? The state has to prove several things that on about the date and place charged, that it was the defendant did something unlawfully, which means without legal permission or justification, i.e., was there a legitimate affirmative defense recognized under the law, right? Defense of person, defense of others, maybe defense of property, not usually so much for deadly force, right? And obviously the other elements in a homicide case, for example, is that, took the life of a human being after deliberation. Then you can always argue for lesser included offenses. From first-degree murder, you've got second-degree murder, reckless manslaughter, criminally negligent homicide, but you really got to be able to make a showing for that. So that's somewhat difficult sometimes as well. But like I said, you just, murder cases are tough. And they were, you get into what I refer to as the trial psychosis hotel. Okay. When you go to trial, even if you know in your mind, these are very bad facts. If they were good facts for you, you probably wouldn't be there, particularly in a self-defense case. You'd be like, it's self-defense. The police recognized it. The district attorney recognized it. It's self-defense. We're out of here, right? Although I did have one a couple of years ago, little road rage incident. Other guy gets out of the car. My guy's walking. My guy, good shot, shoots attacker, aggressor, evil man. One shot in the eye, boom, drops like a sack of potatoes. And, the client at least did the correct thing, go to the top of the hill where he gets cell phone signal and call the police and say, oh my God, it was self-defense. Right? Particularly in that perfect situation, because, there's no video cameras out on this road. There's 2 witnesses. One isn't showing up to court. Makes good facts. Other pro point, you call the police immediately, self-defense. You stay there at the scene. Another pro tip, do that. Don't then, leave the scene and act like nothing has happened. Jurors also do not find that as good behavior. They find that as consciousness of guilt, that you were leaving the scene where you should have probably stayed and said, oh my God, thank God you're here, police officers. I'm glad you're here. Here's the gun. I did it, but it was in self-defense. I know. Hey, could have been something better, like, I know it was in the back, but you should have seen the way he twisted and turned at me. He was coming at me. I did what I had to do, and I would do it all over again. You got to own it. Okay, ladies and gentlemen. So if you talk to the police, affirmative defense, you own it. My advice, still talk to the defense attorney first. And what's he going to say? Just like the mug says, lawyer, 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 goes away. Anyway, needless to say, some of those pro practice points were not followed, and I can explain to you that it can promptly result in one's conviction and then proceeding to immediate sentencing, which is life without the possibility of parole. So, once again, we encourage you not to shoot people, ladies and gentlemen, but if you do, be smart about it and call me, okay? Call me. Call the office. We'll take care of you. 24 hours, we'll get a message. Call me, all right? I'm going to first advise you not to shoot anybody, but if you did, let's not create a worse situation, okay? Just something to think about. All right, so that was my last week, and yeah, let's just say the week got even better from that, but we're not going to even go there. But this week was the start of a new week. What's today? Tuesday. I mean, I know I was in a hearing all day Tuesday, which was fun. You never know what the judge will do. I think we will prevail on the hearing today. It just goes to show that cross-examination is the greatest truth-seeking tool ever invented. Because let's face it, ladies and gentlemen, there are a lot of liars out there in the world. They will lie straight to your face. They will lie under oath. Those little chairs that people sit in, even if they take an oath, it is not a truth-telling chair. It's not like they put a little thing on the hat and they say, oh, truth, lie, truth, lie. No. It's someone's credibility and their answers when questioned on cross-examination. And with those individual stories that are on cross-examination, just make no sense whatsoever. And it's so obvious to everyone in the room that the witness is not telling the truth. You're looking at the judge and the judge is like, hey, judge, I'm just asking the questions of that witness. And, everybody in the room realizes that the witness under oath is not being truthful, except the witness testifying under oath. Because I'm telling you, there's people that actually believe that they can lie themselves out of every situation. It is unbelievable, ladies and gentlemen. But that is the beautiful thing, as I always say in the start of litigation, the truth, or a pretty darn close version of the truth, is going to come out during litigation. All right? So don't lie. Don't lie. It's going to come out. And, even if you try to think you're smarter than everybody else, guess what? You're not. Okay? People are going to figure it out. The truth is going to come out. And whether it's the attorneys or the court that asks the question, or ultimately a jury, And they're going to say, you're not being truthful. And guess what? When juries think that you are not being truthful, that you're lying to them, they will punish you, ladies and gentlemen. They will punish you by a guilty verdict. Okay? Remember that. Always, always remember that. You don't try to bamboozle the courts. You don't try to bamboozle the jury system. Mama Pink, basic crime rules. Oh, that's basic time. I thought she was given basic rules for affirmative defense type cases. But I think we covered that all right. All right. So like we did this a couple weeks ago, and we put up the phone number so people can call in. And at that time, Bryan Kohberger had pled guilty. And I said, if you believe that Bryan Kohberger is innocent, you got first priority. Now, of course, there's always a couple of people out there that's like, oh, Scott, I missed it. Well, here you are, chance again. There's even people that said, Scott, if I missed your show, but I believe that Bryan Kohberger is innocent, you just need to understand this. And I keep saying, well, he did plead guilty to 4 counts of first-degree murder. That's pretty compelling, convincing evidence of his guilt. Most people don't plead guilty to 4 counts of murder plus a burglary, 4 consecutive life sentences to go spend their life in a little cell for the rest of their life, unless they did it. Unless they think, well, the other alternative was something worse, i.e. receiving the death penalty. But I said, I'm being fair. I said, this particular subscriber, viewer, and I said, listen, here's an email. Send Frank an email. We'll send you a link. We'll do a show. You can come on live and you explain to me and the rest of the world why you still think Bryan Kohberger is innocent. Now, and what I've noticed, and here you can see here, we've pulled these up. These are the various records from the Idaho State Police. All right. And these are, the cops did a really good job. They went through and they talked to everybody. And if something is, what's the word I'm looking for? Is something, is right, they put it in there. This stuff is really quite interesting to show. The interviews between the roommates, I wish these weren't redacted. This is the problem. I hate redacted documents. I know. It's a redacted document because they have to protect the privacy. Really? But by this point, doesn't everybody really know what's going on? But, these people were just eyewitnesses. These people should not be harassed. Okay. And even if their name showed up, neighbors saying, hey, here it is. This is what I saw. This is what I observed. Nobody should go harass them. Okay. And let's face it. We've talked about this before. If somebody thinks they are a keyboard warrior and, that's the only way they communicate, you're a coward. All right. If you're going to threaten somebody and, say, this is what you're going to do, or, go out and try to do stuff, a keyboard warrior stuff, you're a coward. Okay. Should be able to do it straight up, to the person's face. That's what I love about court. So many times you get a bunch of keyboard warriors. I've represented guys that they were just the meanest, nastiest people, do the most meanest, nastiest things behind the keyboard. And then, they send you emails, had clients that would, be like, dude, they're going to dismiss the case. All you have to do is leave town. That's how much they dislike you, right? And, have a client so they respond back like, F you, right? Then you go see the guy like, what's wrong? What are you talking about? They're going to, oh, I'm sorry. I didn't mean that. Most of those keyboard warriors, bunch of cowards, ladies and gentlemen. They're cowards. They're bullies. They're thugs. And you just got to kind of punch them in the nose and let them know that you're coming for them. So these redactions, I get it. It's that, but God, it's so hard to read. Thank God when, you have a case yourself, there's no redactions that are made. You get a complete copy of everything. But when you go through these various documents, it is quite obvious that the police departments in this case, did a very, very good job as it relates to um, all of the investigation in these matters. And going through it, a lot of it is not earth shattering, but it shows the thoroughness of the police in this particular situation. They literally left no stone unturned. I was reading the document the other night, as I was, trying to go through all this stuff. I obviously have a day job. I was in a homicide trial last week, but I'm still trying to go through it as quickly as I can. I mean, there was a tip for a guy that had purchased 2 K-bars, but they were purchased after the homicides, but it freaked somebody out. A neighbor, I think, saw that he had purchased these knives, and they went to interview this guy. His name isn't identified, and they talked to him, and he gave a DNA sample. He was cooperative, and his rationale was, well, I bought 2 K-bars because I heard that was the knife that was used, and so I thought, well, maybe the person's still out there, so they may have 1 K-bar, so I'll have 2. And well, guess what? It didn't quite, happen that way. But ultimately, they found the guy was harmless, and he realized, you know what, that really doesn't make that much sense. But he got scared, and that's the type of thing that you realize, and when these investigations go on, most people want to cooperate with the police, which that's good for society. We want them to. Citizens to cooperate with the police so we can get the bad guy, right? And it's just like the witnesses, like Morton's, the Miss Mortensen, who is the roommate in the house. People have been so mean and disrespectful to her. It was just amazing to me. I mean, some of the comments that people made. Okay. But if you go back, I think it's one of the first documents in this entire thing. Let me go back this way. Anyway, the detail in which they went through her, basically that weekend to see if there was anything unusual. They'd gone to the sorority event that night, the previous night. Thereafter, it was, I think it's document number 3 in this. The level in which they went through the day, it was thoroughness. These police were trying to do a very, very good job. And frankly, they did. They got their guy. But I want to talk to you about something about this. Maybe let me know what you all think about it. Okay. I'm not saying it's any easier for police officers these days, but there's so many more tools available to the police officers these days. I mean, think about it. You go back 20 years, you didn't have a plethora of cell phones. They didn't get cell phones for this. They didn't have all the cell phone data. They weren't routinely pulling cell phone data from cell phone towers or anything along those lines. You couldn't do all these phone dumps. There wasn't as much surveillance footage. I mean, I remember that was always a great cross-examination. Well, detective, certainly you could have recorded that, wouldn't you? Right? You wouldn't record it. You could have. It was so simple, but you didn't. And it was a great cross-examination, raised reasonable doubt many a time in a trial for that. Now you get body cam videos. I remember back in the day, so to speak, you would raise the issue. The client would say, before they started recording interviews, the police beat me with a rubber hose. Well, did you record it, detective? No. Okay. So the client gets up. He's like, yeah, the officer threatened me, beat me with a rubber hose, you name it. And then the judge would make the determining factor, judging credibility, all that good stuff. And I'd say 99% of the time found for the prosecution. But then, for example, I know in Denver, they started recording everything. And other jurisdictions, like, we're not recording them. How dare they, think that they can't trust police officers. And now I know police officers, detectives, they're like, I don't leave home without it. This body cam has saved my career because people have made allegations. And we're like, let's just go to the film, right? And The other thing that's rather interesting is police used to get complaints at a very high rate. And now what do? The independent monitors that look at this internal affairs, what do? Let's go to the tapes. They go to the body cams where the police officers have to turn these body cams on anytime they're interacting with the public, anytime that they are involved in an investigation, basically doing police work type stuff. And it's defined, different ways, but that's it. And if they fail to turn that on, then they can, there's a statute here in the state of Colorado. It says if they fail to turn it on, there's a presumption, a rebuttable presumption, which means they can present some evidence that did not happen. But that it is a rebuttable presumption that there's no misconduct, nothing nefarious going on, some sort of alleged misconduct. So it's just a different time. So like I said, the police have a lot more tools to get this stuff. A lot of it's the digital data, right? The cell phone towers, the GPS, the pinging of the phones, Wi-Fi, you name it. There's so much technology that just leaves this digital paper trail for the police. All they got to do is go find it, right? So I have so much more respect for those detectives that I used to cross-examine, 20, 25 years ago, who didn't have all that stuff. It was just, we got a murder. Got to figure out who did it. Well, who was the last person here? Let's start there. Let's go talk to the neighbors. Oh, they didn't just say, hey, can we get access? They type in, can we get access to your Ring camera and everything during this time period? They didn't have all that stuff. Think about it. It is good old-fashioned gumshoe detective stuff. And like I said, not disparaging the police of the day. They do an excellent job, and they did an excellent job in the Kohberger case, but they've got so many more tools to use. I just have so much respect for those old detectives, man, solving cases without the stuff that is just so routine. We can't find this guy. Let's go ping his phone. All right, we got his phone. Let's search his phone. They search his phone. His car. Let's search his car. Let's see what we can do. Get the data. Where was he? Most of it's going to come from the phone, but they didn't have all that. And so to put a case together, think about the respect you have to have for those detectives back in the day, putting these cases together where they didn't have DNA evidence, right? Yeah, they had some real questionable stuff too, right? Oh, the fingerprint evidence, not exactly the best. Hair follicle evidence, things like that. So the reality of it is that just so much respect. And today it's just so much easier, but there's just so much of it. I remember we don't do many DUI cases anymore. I just find them boring because it's all on video these days. And what used to take literally, there used to be judges. I remember in Boulder County, you could do 2 DUI trials in a day, one in the morning, one in the afternoon. Why'd you pull the person over? Weaving. All right. What'd you observe? Bloodshot, watery eyes, slurred speech, odor of an unknown alcoholic beverage. He consented to a blood test, a breath test. He's above the legal limit of 0.080. Jury, maybe a little cross-examination on the field sobriety test, those types of things. No, but, boom, jury gets it. I remember they would have notebooks with all the jury instructions. They would be labeled, and they would just put in grease pen. They would just change the defendant's name because they were just stock DUIs. And now I'm hearing people doing DUI trials that are taking 3 days. Like, I've done homicide trials that can get done in less time. My homicide trial last week, it was on video, 5 witnesses. We could have been done by Tuesday afternoon had the prosecution kept all their witnesses available. Seriously. Example of a simple case, and 25 years ago would have been a much better case because there wouldn't have been any video of it with your client, big as day, twice as ugly, sitting there chasing somebody down. You know what I'm saying? So it's a different time. Complete respect for everybody. The detectives. And like I said, I love detectives, man. It's a jousting game. I remember one of my first homicide trials. I did it with a legendary attorney, Peter Bornstein. And I'm a young attorney. I just gotten out of the military. He said, "Hey, you want to do this homicide?" Yeah, I want to do this homicide case for me. And he goes, "Your job is to handle the crime scene." Okay. And it wasn't all in digital. It was literally, photograph size, stuff you hold up, right? 8x11 photos, and they were printed out. And it was tough to get copies of them because it was expensive. And, maybe they had like a VHS tape recorder that they walked through the crime scene, whatever. And, just going through, all right, detective, whose shoes are those? I don't know. Could those have been the killer's shoes, right? And you're like, no, and you see the detective, and things were so much more collegial back then. It's weird. It's very weird. Back then you could talk to the detectives. Hell, I had homicide detectives that we got along so well. I was like, hey man, can I get a Denver Police Department hat for my kids? They would love that. They just think that was the coolest thing. One day I'm in court, detective shows up. Hey Scott, I got that DPD hat you wanted. I'm like, oh, that's cool. I said, that's so cool. Maybe I'll wear it. And he goes, nah, don't do that. We don't want somebody to think you're, on our team or something like that. I was like, okay, I get it. It's just for the kids. But it was just more of a collegial time. Now everybody just takes everything so personal. It's so weird. It's litigation, and it shouldn't get personal. You don't go around demeaning it, but you just basically, like I said in those old days, whose shoes are that? Now your theory, detective, is that she was sitting there watching TV and she was shot in the back of the head and she's laid out on the floor, right? Yeah. Well, let's take a look at this crime scene. Do you notice the dress is all pulled tight? It almost looks like the body's been staged. Are you sure that's where the crime scene took place? Well, we think so. It was just, I don't know. It was just a different time. But, those old school detectives, man, I look back, I just love them now. Now all these detectives just do is, let's get the phone. Let's get the phone. Get the phone. They engage in an illegal search, overly broad search. I know I'm being general, but, searches are supposed to be specific as to what they know they're looking for, right? If the police think that they have probable cause that you have drugs in your house, they have to say what drugs they expect to find. All right. They don't have to say the exact location where it's going to be, but they have to say that we believe there's going to be drugs and the reason why there's there. For example, maybe somebody was selling drugs in the house and they'd sent a confidential informant in, and the confidential informant saw guns and drugs or something to that effect. Goes into the warrant, as long as it's not stale, usually after 10 days from the date that the warrant is signed, they come, they kick in your door, and they find the drugs, right? Now these days, so that's the example, right? They have to be specific what they think they're going to find, what they're going to do. Now they just say, the defendant had his phone. Based upon my training experience, everybody carries a cell phone. The cell phone will tell me where the person has been. I believe it's not uncommon for criminals to talk about the crimes that they committed on their phone. Therefore, we would like to access the phone and look for those chats. So they dump the entire phone. In my opinion, completely illegal. I think the court's finally catching on after, little old me and others making that argument. It's basically, what the Fourth Amendment is prohibits, what the Fourth Amendment prohibits, right? Fourth Amendment. The colonists were like, hey, the king didn't like us. And he would just come in and kick in my door and search around the place and say, we know you did something. We heard you didn't like the king. You said something disrespectful. We're going to find something to charge you with. We don't know what it is, but we'll know it when we see it. And they would go through and tear up the house, and they would, we found it. Look at what this is. They didn't know it was there. So the founding fathers, the colonists, said, No, they have to have probable cause by a neutral and detached magistrate under the Fourth Amendment to be able to go look at it. They can't just go and do that, right? But that's what they do on the phone searches these days, ladies and gentlemen. I know I'm digressing just a little bit, but this is interesting stuff because it's so prevalent in today's world. So they go in there and let's say they assume they have the passcode. All right. If not, they use gray key, right? Gray key magic. Ooh. Where they plug it in. It comes down from the web, goes into the phone, then somehow transforms it back into the web where they crack the code for the passcode, and then they get in, and then they dump it and they put it in a Celebrite, and then they put it in an RDF reader, and that's the whole phone. But then they say, "Trust me, detective, government. I'm only going to look for what I really think it's there." Now, of course, I have to go into every room because, those criminals can be sneaky and hide things. So I got to go search the entire phone. I'm not sure exactly what I'm looking for, but I'll know it when I see it. And then I'll look at it and all the stuff that's there. Sure, I looked at it, but I'm not retrieving it as evidence. How is that not a rummage under the Fourth Amendment, ladies and gentlemen? It's totally a rummage under the Fourth Amendment. And courts are finally starting to get onto this. But the prosecutor's arguments are that, well, we don't have the technology, Judge. Well, you didn't have the technology to crack the phones. And then necessity being the mother of invention, somebody invented gray key in an effort to crack the code. First it goes, well, let's see what we can find in this particular passway. Let's see if we can get into the passcodes of the phone. Well, let's see if the PIN number's in there. Is it 4 digits, 6 digits, right? Cracks code. Necessity is the mother of invention. And I guarantee you, if the court said, you can't do this general search, you have to know that you're looking for emails between this defendant and this particular person during this particular time period, being specific, that's all that you should be able to look at. But they can't limit those searches. They have to dump the whole phone. That's like searching the whole house and then saying, but we didn't look anywhere else, promise you. Yeah. Hopefully somebody gets outraged by that because that's outrageous under the Fourth Amendment. All right. Let's take a look here. Boy, did I get on my soapbox there on the Fourth Amendment. Oh, we've got a call. Who have we got, Frank?
Oh, we have Ellen, I think.
Ellen?
Yep.
Hello, Ellen.
Yep. How you doing?
Oh, it's Alan, maybe.
How you doing?
Good.
I got a question about how much can they keep from Kohberger's canteen to pay for his fines and everything? I think Hitler did a very good job about how much he fined him and everything, but I don't think there's a trick in there, I think.
Yeah, so normally what takes place, and I'm not going to think that I know it off the top of my head, but normally if a prisoner gets money on their books, right, either through working or family members or all the infatuated fans of Bryan Kohberger send him money so that he can live a comfortable lifestyle in prison there in Idaho for the rest of his life. Usually the state gets like 10%, okay, whatever comes in. And obviously the more that comes in, the bigger it goes to pay the fines. Now, Judge Hitler did impose a fine for each case. I think it was it $25,000 or $5,000? I can't remember off the top of my head. But he did that so that any monies that come in are going to get garnished from Kohberger's canteen account that he has set up.
So he's not going to get as much as what he would hope he would get.
No. Hold on one second. Let me just try to look something up. See if I can get an answer here. So let me just take a quick look here, see if something pops up. And that's the whole point. You have to pay restitution, and even if something, what's the word I'm looking for? Something crazy happened. What's the word I'm looking for? They would still take his money. Let's say, for example, it's not Bryan Kohberger. Let's say somebody like I have a former employee that stole lots of money from me years ago. We prosecuted him both civilly and criminally. He went to prison. Hasn't paid a penny on my $1 million judgment I have against him. And the restitution, which is, $1 million or whatever it is, close to that or whatever, I get a check for $49 every month. Woohoo! That ought to be paid in no time, right? And they can garnish his, any tax. But this guy, he's a bum. He's not working. He's got a girlfriend. He doesn't own anything anymore. So that's it. I did find out, and it was correct. Kohberger was ordered to pay a total of $270,000 in fines and civil penalties. This includes $50,000 fines for each of the 5 counts for the first degree murder, and a $5,000 civil penalty for each of the 4 murder counts payable to the victims' families. Okay. So apparently under Idaho law, they can impose a civil penalty of $5,000. So there's no $20,000. And under Idaho law, 20% of each deposit into Kohberger's prison account is going to be paid to the Idaho State Board of Corrections, and they will forward the money to the clerk of the court for payment to the victims, more than likely paid in, equal share. So hopefully that answers your question, but that's the way it generally works.
Just so long as he's not living a comfortable lifestyle, that's my point.
Yeah, I mean, think about it. If mom, Bryan Kohberger's mom wants to send him $100, 20% of that, is going to go to the state. So, it's going to make a dent. But eventually, I mean, think about it. Eventually, Kohberger's parents will die. They won't send him any money unless they, send up some trust for him. Maybe his sister will send him some money. I'm sure there'll be some weird person that's going to send him money. And remember, that's for commissary. So that's so that he can buy toothpaste and, any food items. Remember, he's getting 3 hots and a cot already, right? They serve him food.
Oh, yeah.
I mean, I don't get 3 hot meals a day every day. He's got it pretty good. He's going to be fat and happy. He can sit in there and, do whatever he does. Maybe the obsessive compulsiveness will absolutely drive him bonkers while he sits in there. But, this guy, the commissary is to make his life a little more comfortable. And, it's a big deal when people are in custody for a long time to get commissary. Because if you don't, you're eating all the slop in the jailhouse. And most people don't rave about prison food. I've heard them rave about small county jail food, but not prison food.
Well, that pretty much answers my question. I've always wondered how much can they legally take from him, and yes, he needs to be to a certain comfortable level, but he doesn't need to be that comfortable.
Well, according to Idaho law, 20%. So the government, hey, just like everything in life, ain't nothing legal till the government gets their cut, right? Well, they're going to take their cut, 20%, but it goes to the victims. So it's a good cause. But obviously 20% would never, ever replace, obviously their loved ones. And it would never, ever, bring anybody back. And it's almost insulting, when they're going to get, a few cents, maybe a few dollars every few months.
No. Well, too bad well, I'm not going to get on that soapbox. All right. You answered my question. Thank you. Have a good evening.
Great. Thank you. Thank you very much. Thanks for calling. See, everybody, see how simple that was? Call in. We have a conversation. Only requirement is don't listen through your computer. You got to talk with the phone. Turn the computer down because there is a delay over the internet kind of thing. And just have a conversation. All right. Who do we have next, Frank? No name. All right. Caller, you're on the air.
Hello?
Hello. Who do we have?
Barbara,
Good evening, Barbara. How are you? What's on your mind?
I am good, Scott. Hey, I am really stressed over this issue that I've been trying to get your attention about concerning Bridget Todd, who was the lead attorney for Carly Gregg, who was convicted of killing her mother back in September of 2024.
Okay.
Now, it's been brought to the attention of the appeals court in Mississippi that while Bridget Todd was her attorney, she was going through a divorce at the time, and she filed a lot of untruths and false allegations against her now ex-husband in court, and she used the court system there to cause this man to have to move out of his own home. She somehow managed to get temporary custody of his children from a previous marriage. I mean, the 37-page motion that was filed by his lawyer on July 4th of this year is just full of unbelievable things that she put this man through.
All right. So
Now
So let me just, for people who don't know, the Carly Gregg case was the case in Mississippi where she was a teenager. I believe she's about 15 at the time. She kills her mother, attempted murder of the stepfather who lived. And this goes back to 2024. And she was sentenced to life in prison without parole and attempted murder charges, and another 10 years for tampering with evidence, right? Does that sound about right?
Correct.
Then the ineffective assistance of counsel claims that they're alleging is that the trial counsel, Bridget Todd and Kevin Camp, did not sufficiently develop or present evidence supporting Gregg's not guilty by reason of insanity plea. Is that what you're talking about?
Well, from what I'm understanding from the article that I'm reading is that because of all of her untruths in the divorce proceedings between her and her husband, because of the way she manipulated the court, now there's question in how she handled Carly Gregg's case. And so that's why this new attorney who is filing this motion to get a new trial for Carly has filed this motion.
Okay. So they're saying that they didn't prepare for an appropriate insanity defense. They missed an opportunity in their expert witness in regards to Gregg's mental instability. But the appeal claims trial counsel failed to counter the prosecution's expert, Dr. Pickett, who argued that Gregg knew right from wrong. The appeal suggests counsel did not adequately challenge Pickett's conclusions or present additional psychiatric evidence. They also say that they failed to address pretrial publicity, basically claiming that the extensive pretrial media coverage biased the jury pool. The appeal argued the trial counsel did not sufficiently push a change of venue. Now, I remember we talked about this case when it was going on. We may have actually covered it, didn't we, Frank? But it was over really quick. Inadequate handling of the rapid timeline. The trial occurred within 6 months of the crime. Oh my God, usually within speedy trial time, right? Which the appeal argues limited counsel's ability to prepare a robust defense for a complex case involving a juvenile facing life without parole, and failure to mitigate sentencing for a juvenile. Okay. I don't see anything that I'm checking here that specifically goes into the attorney's private life, but I mean, nothing here particularly jumps out with me. I mean, do you think that she didn't do it? I mean, they're basically saying it's an NGRI.
Oh, no, I think she did it. She most definitely did it.
Okay.
I have no doubt.
Okay.
What I'm concerned about, here's what I'm having an issue with. I feel like Bridget Todd, number one, should be disbarred for lying to the court.
Well, what specifically? I mean, you can't just make a broad accusation that she lied to the court. What did you
Well,
think she lied about? And then what evidence do you have that somebody actually lied?
it fell in the 37-page document that her ex-husband, his attorney, which is Jackson Jambalaya, he filed that motion on July 4th. And she's admitted to all of the lies that she
what lie specifically? Tell me what lie specifically you're relying upon.
I'm trying to, well, such as domestic violence claims. She claims, you know, she had claimed at the time that he had hit her and so forth, and then turned around when it came time to tell the truth and said that he didn't hit her and so forth.
Oh, gee, a recanting victim in a domestic violence case. Wow, I've never heard of that one before. How did that affect her case here? The case that she represented
because
Carly Gregg.
Because the new attorney who is now representing Carly Gregg found out that this 37-page motion against her had been filed, and he's now using it to try to get Carly a new trial.
Okay, but I don't understand what her own divorce matters have to do with
I think
Carly Gregg's representation.
I think they're questioning her psychic. What do you call that? You know, I think they're questioning Bridget Todd's psychiatric abilities. You see what I'm saying? Was she capable of handling her job as attorney for such a high-profile case? Are you following me?
No, I understand what you're saying, but you know, I mean, attorneys are humans too. They have stuff going on, and what they're saying is that she didn't adequately prepare for an insanity defense. They went with an NGRI defense, and it didn't work. And now they're saying, "Oh, well, you didn't fully explore her mental health history, including her recent medications. She switched to Lexapro and bipolar disorder diagnoses, which could have bolstered the defense, okay? That's the argument there. And I'll be honest with you, I get so tired of post-conviction motions, okay? And I know it's the nature of the beast that if somebody goes down on a case, they're going to file a post-conviction relief. I've had clients that's like, "Oh man, Scott, I love you, man. You beat everything, but I'm still doing this bunch of time. But I need you to file a post-conviction relief motion saying you were a bad attorney." I'm like, I'm not going to do that because I didn't think I was a bad attorney, you know? "But Scott, man, you can just do it. I need you. You're my attorney. You're my boy." And I'm like, I can't do it. You got to get somebody else. You got to do it yourself. And then maybe they'll appoint you an attorney or something, right? And it just drives me bonkers. And I'll be honest with you, a lot of the attorneys that prepare these 35C hearing, you know, the ineffective assistance type issues, they haven't looked at it very close themselves. Usually they're under deadlines and they gotta go with what their client told them. They file something to get it in, and then they request to amend it. All right. And most of the time, I hate to say it, but the person spending the life in prison, even though they probably love their attorney, thanked him, was all on board with the case strategy. And, you know, during, "Oh, you're doing great. You're high fiving this. Oh, it's going great." And then you lose and they're like, "Oh, my attorney sucks. He sold me out. They didn't do this. They didn't do that. They should ask this question. They should ask that question." Okay. So I am very skeptical of post-conviction relief. And most post-conviction lawyers, most of them never tried a trial, you know, in their life. Usually or if they did, they realize they're not very good at it. And so then they go do the appellate thing. And there's lots of smart appellate attorneys, and there's very good post-conviction attorneys. I have a friend that does lots of post-conviction stuff. He's made a very good living for himself. And he's really expensive. But he, you know, of 10 cases that he gets contacted on, he maybe takes one where he thinks it's actually legitimate that he's willing to put his name on. Okay. So just like Carly Gregg was entitled to the presumption of innocence, the trial attorney, okay? Because everybody plays armchair quarterback with the trial attorney. The 6 months, hey, that's within speedy trial. Maybe that's what the client wanted. I bet you this attorney has some copious notes about conversations with her client. And when she's forced to testify, guess what? Attorney-client privilege is waived. And guess what? The attorney then, unfortunately, has to throw the client under the bus because they do have those copious notes saying, I advised the client I could really use more time, but the client insisted on going to trial and speedy trial. This was a tactical decision. I went along with it. I told her I needed more time, resources, etc. And so color me skeptical. 35Cs always look very colorful. Oh my gosh, it's the worst attorneys in the world. I can't imagine how the state in like a death penalty case or a juvenile life without parole case just managed to find the worst attorneys in the entire state to represent somebody on the highest profile case going on at the time. It doesn't work that way. Okay?
Okay, but I just have a problem with somebody that can tell a man that if she gets pregnant, even if it's through IVF, while they are married, that he is going to be financially responsible for that child, even if it's not his child. And that she is okay to represent a criminal defendant in court, and everybody's going to be okay with it. You see what I'm saying?
I don't see how they're related. Their marital dispute, how is that affecting her? And remember, on a post-conviction relief, you have to be able to show that, one, counsel was ineffective under the Strickland standard. And the Strickland standard is basically, if you can fog a mirror, you're effective. Okay? There's cases, the United States Supreme Court has said defense counsel that fell asleep during death penalty cases were drunk, that they weren't ineffective. And even if you get over that very low bar of Strickland, then you have to get to the point where it says it would have made a difference. It's a multiple prong. And the fact that she had divorce issues and her husband now in a divorce is saying that she said something different and she's untruthful. So what? How does that affect her representation of Carly Gregg?
So you're saying that attorneys can lie to the court?
No, attorneys shall not lie to the court.
Well, that's what she did, though.
In Carly Gregg's case, she lied to the court? Is that what you're saying?
No.
Okay, there you go.
In her divorce?
In her divorce case. Then you know what? She should be grieved based upon her conduct in the divorce court. But they're not interrelated.
Okay. And you don't think she'll be disbarred because of this?
Okay, but let's say she gets disbarred after the trial. Doesn't mean that she was an ineffective attorney during the trial. She still had a valid law license.
Okay, that's all I was worried about.
Okay.
That's all I was worried about, because I don't want Carly Gregg to get out of prison.
Okay, she's not going anywhere. She killed her mom.
Okay.
She set him up. And if I remember correctly, she also had her boyfriend or something help her, didn't she?
No, I don't believe. I think there was a lot of speculation that there was some kind of a nefarious relationship between her and her stepdad, but I never bought into that theory. But I know a lot of people thought there was.
Yeah, the 5-day trial focused on Gregg's mental state, with her defense pleading not guilty by reason of insanity, citing a medication switch, Lexapro, and bipolar disorder diagnosis. Defense expert Dr. Andrew Clark supported this, while prosecution expert Dr. Jason Pickett argued Gregg knew right from wrong, describing her actions as diabolical. The jury rejected the insanity defense after 2 hours of deliberation. My God, sounds like my case. 2 hours of deliberation. Maybe it was 3. They ate their lunch. They got their lunch. Okay. She's not going anywhere. Okay. And if this attorney gets disbarred for making misrepresentations to the court as an officer of the court in a divorce matter, then she should be held accountable. But that's not like you wipe out all of her cases that she worked on.
Okay.
It was a slam dunk case. I believe there was surveillance footage showed Gregg pacing with the gun
Yes, there
before
was.
the shooting and hiding a security camera afterwards. There was a lack of remorse and premeditation, including her statement about having, quote, 3 more, end quote, bullets for her stepfather, who she shot, and he survived. It wasn't a whodunit. This was a Hail Mary. Let's get the trial. Let's see if they can't be prepared in that time.
Right.
That's called good strategy. When you got nothing, you got to create something from nothing.
Well, one thing I'm glad that at least Bridget had the guts to do, and that was tell the truth in the end of the things that she lied about during her divorce. So,
well, nobody
that
should
much I'll
lie in
give her
court.
credit for.
Nobody should
No,
lie in
they
court.
shouldn't. I agree.
Attorneys cannot lie to the court. You have a duty of candor to the court. And if somebody does that, then they should be held accountable. I'll be the first one to say that. Heck, I had a hearing. I had a hearing where a pro se defendant on a case was accusing attorneys of fabricating evidence. Oh, really? What evidence do you have of that? Well, I didn't do it. Well, let's talk about that. By the end of it, they looked really stupid. Okay. And it turned out maybe he wasn't the one telling the truth. We'll see what the judge does, but I don't think he scored any points. So the reality of it is, no one should lie in court, but there's no truth serum there. But if I always lived by it, and every attorney I think should live by it, is that you like your law license and you've never been paid enough money to jeopardize your law license for a particular client, right? Not going to lie for them, not going to cheat, fabricate evidence. No, you're not going to do that. Because I've never been paid enough to jeopardize my law license for that. And you have a duty of candor to the court. I mean, you may like your client. You think they may have a righteous case, but at the end of the day, they're your client and you're not going to jeopardize your livelihood and your career for them. And listen, it's a divorce case. I don't do divorces, right? I think I've done 2 in 30 years and I would never do another one again, ever. Everybody lies in their divorce case. Everybody. So
Okay.
I would take that with a grain of salt.
Thanks
Thanks for your call.
You're welcome. Have
Bye-bye.
a good evening.
Bye. That was Barbara, right? I love Barbara. She's called in before, right? But you can't just make blanket allegations. Well, this attorney lied. Well, hey, before you do that, let's talk about what, and then suddenly, well, maybe it wasn't a lie. Couldn't recall it. Do we have another call, Frank?
Yep.
All right. Who else do we have? Beverly.
Hi, Scott. Love your show, and thanks for taking my call.
Thank
and
you.
Sorry, I'm not a Kohberger.
You're not a
But I
pro
wanted to-
Kohberger?
I'm not. That's right. But I wanted to ask why in the world they wouldn't make him confess, at least to the police, where's the murder weapon? How did he get out of the house with all those bloody clothes and not get any in his car and stuff like that? I mean, it worked for Dennis Rader or Gary Ridgway. I mean, now we have the answers to those questions.
Yeah. I mean, technically, he's not required to do so. Okay. The court
Okay,
couldn't make it.
that's
Remember
consistent.
Judge Hippler at the change of plea hearing said, I know a lot of people have contacted the court that I shouldn't take this plea and I'm not going to be influenced by outside forces. And, people want to know why, maybe it was the sentencing where they said it over or something, why, I didn't ask for more, because he can't make the defendant do something that he's not legally obligated to do. He admitted to the elements of the offense. He admitted that he did it. I mean, frankly, I get it. We'd all like to have more answers, but at the end of the day, it doesn't matter, man. He admitted to cold-bloodedly, after deliberation, killing 4 people that he had no right to do anything to, and he did it. He admitted to it. He confessed to it, and he will forever be known as a quadruple murder. murderer.
Okay.
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 But the judge couldn't do
Yeah.
it. I mean, I would love for him to do it. I would love to know exactly what he did. But my guess is,
Yeah.
I think the reports indicate that, they think he went down to some little town. I think he had lunch or a coffee or something, and then walked around or something to that effect. I think he threw it in the river, and chances of us finding it slim to none by now. 3 years later,
Okay.
current washing it down. And even if they did find it at this point, there's no way that they could prove that it was actually the knife. But he admitted to the elements, right?
Okay.
Every
Yeah.
defendant, think about it. Every defendant has a right to remain silent because anything you say can and will be used against you. When people go to
Okay.
court their first time, they get what they call a Rule 5 advisement. And it says, the advisement, and they're told by the judge, you don't have to say a word. But if there is any plea in the future, any plea must be knowingly, voluntarily made. All right. Not through the force of any coercion, undue pressure, or influence by anyone. And Judge Hippler
Okay.
went through that colloquy, asked Bryan Kohberger, are you pleading guilty because you are in fact guilty? Did you do this? Now, I would have asked, and I always raise this, there's good judges and there's great judges. All right.
Okay.
Great judges ask the defendant, tell me in your own words what you did. Right.
Thank you. That's what I would have liked to have heard, something to that
Yeah.
effect.
Now, he did say, how do you plead? Technically, all the judge has to do is they read the charge. It's accused by the, under the Idaho Penal Code, whatever statute, the Bryan Kohberger unlawfully, after deliberation, took the lives of Kaylee Gonzalez, right? On this date after, but that's all he's technically required to say. You admit to the elements, you for therever after are legally and factually guilty of whatever you pled guilty of.
Okay.
So he, all these people that say, oh, Bryan Kohberger is innocent, he got railroaded, he was pressured, his attorney was terrible, right? Listen, Bryan Kohberger, this guy's a coward, okay? He is an arrogant coward. He's kind of the equivalent of, some sort of troll out there. He thinks he's the smartest guy in the room, when in reality, well, he may be smart. We'll give him that. But he's not street smart. He's not competent. And, this guy had issues with women. I'm assuming he was absolutely terrified of them. And he just did it. I mean, he's a coward. This guy's not going to go file any post-conviction relief. He's not going to file any appeal because even though he touts himself as, being pro-death penalty, apparently he's maybe not so much in favor of it when it comes to him. So
Exactly.
he's a
One more
coward.
question.
Bryan Kohberger is a coward. Okay.
Oh yeah, no doubt.
He killed 4 people. At least 3 were asleep. At least 3 of them were asleep when he killed them. I mean, that's pretty damn cowardly.
Well, see, we'd all like to know why Ethan, if he managed to sleep through the whole thing, maybe he didn't. Who knows? And we'll never know for sure, other than to speculate, which is annoying.
Yeah.
So I have another question regarding this. I can understand why the defense wanted to make this plea, but since the prosecution accepted it, are we to infer from that maybe their case wasn't the slam dunk we all thought it was?
No. And let me tell you why.
Okay.
No, I would not infer that the prosecution thought that they had a concern that they were going to lose a trial. Now, is there always a concern? Has the prosecutor lost a case that they thought was a slam dunk? Yes. Any good prosecutor will tell you that. Okay. Just like as a defense attorney, I have won trials I should have lost. Okay. And I've won some, I've won some that I should have lost, and I've lost some that I thought I was in the game on, where I should have won, and the jury comes back guilty. Right.
Yeah.
And a good prosecutor say like, oh man, I lost. I remember sitting in the courtroom just up the road here from our Crime Talk studio offices here. and talking to the DA, hey, how's it going, man? Anything interesting? I was in trial last week. Oh my God. I think I'm going to lose all faith in humanity because, they walked this guy on a sexual assault on a child case. And I can't believe I lost. And I'm like, wow, I get it. But, the jury has spoken. And she was literally crushed by it. Now she got over it. I think I saw her a couple of weeks later and she was back in the game, so to speak. But that's what happens, right? But you lose the case that you think you should have won. There's always that possibility. And that always creeps in. That always creeps in plea negotiations. But the defense went to the prosecution and said, my client, if you were maybe to offer it, would be willing to plead guilty straight up, 4 counts of life without, parole, and we'll even throw in the burglary. So please, consider that. I mean, this man's going to rot in prison and die for the rest of his life. Right?
Yes.
He's 30 years old.
I don't think he's going to do well in prison.
He's 30 years old, maybe 20 years of appeals, right?
Right.
Post conviction, if he had gone to trial and got the death penalty, he'll probably be dead by then. Okay. And if inmates get to him, they'll Dahmer him, somebody will Dahmer him and slice and dice him in custody.
Okay.
And I bet it may not be now. It could be 5 years from now or 10 years, but somebody will slice and dice Bryan Kohberger up just like he did those 4 young teenagers. Okay. Young adults.
You know what? That sounds like it might happen.
Yeah. But Kohberger, he would not, the defense couldn't go and make that deal, even ask for that deal, unless he had given them authority to go say, I'll take this. All right.
Okay. Yeah.
So they knew they were looking. He read the discovery. Hell, I've read most of the discovery and it's only been out a couple of weeks. You think he read it over the last, almost 3 years? You bet you did.
Yeah.
You think he watched every video? Yeah. Do you think Mr. Kohberger, who thought he was so sneaky, so smart, Mr. PhD candidate in criminology, looked at it and realistically said, man, the jury could believe this and I could get convicted. I need to cut my losses. So I don't think it had to do with the prosecution thinking they had a weak case, but I think it had to do with finality, right? When somebody pleads guilty, there's no appeals. When somebody pleads guilty, zero chance. You can always file post-conviction relief saying my attorney was ineffective. But guess what? Right. Whoever is sitting on the bench when that comes in, all they have to do is say, hey, can we pull up that transcript to Bryan Kohberger where Judge Hippler asked him all the questions? Did you do this? Admit the elements. Is this what you did? Right? Boom, boom, boom. Is anyone forcing you, pressuring you? Have you had enough time to review all the discovery? Yes. Are you satisfied with your attorneys? Yep. There's no basis in which to withdraw the plea.
Okay.
Right? The judge asks, are there any side deals that I'm not aware of? Anything, any promises whatsoever that I should know about? Because if it's not in this plea agreement, it doesn't exist. No, sir, that's it. No one's made me any. That's called a sub rosa agreement, right? No sub rosa agreements. Goes away. So he's done. He's finished. He's guilty of sin. I know we would all love to do it. You find out what it is, but who knows? Maybe somebody will befriend him, start writing him letters and saying, oh, Bryan Kohberger, you're the sweetest, most handsome guy in the world. I can't believe that you would do this, but there's something so, interesting about you that I just feel like I need to get to know you better. And then he starts writing pen pals, and maybe this person will say, hey, I can make a few bucks by, finding out what's in what's in his mind. And he wrote it to me, and, he said, yeah, he did it. And he chopped him up and, told me all his deep, darkest secrets, and they'll try to make a few bucks off it out of that way. Bryan Kohberger needs to recognize he has no friends. He has no real allies. They will turn on him. They will.
Okay. I do have one more question, unless you have a bunch of callers.
Go ahead. One more question. Go ahead.
I'm talking about these people now that study serial killers, mass murderers, and all that. And they say they're doing it so that they can identify and treat and blah, blah, blah. But what are you going to do even if you do identify? The 6-year-old kicks his cat. Are you going to lock him up the rest of his life, or 15-year-old? I mean, honestly, I don't know if there's actually any treatment for it. That's what I'm.
Well, that's an
concerned
interesting
about.
thing, right? I mean, obviously, we know one of the emails there at the university, one of the professors that had interaction with Kohberger and saw the way that he treated people said, this guy's a predator. He's dangerous, right? So
And
you
she
can
said,
see it.
He was right.
You can see it. Those type of things are predictable, but you know, we don't lock people up for their thoughts or because they're weird.
That's right.
But when something
Do
bad
you think
happens,
that
then we all go back and say, well, I guess we should have done something, but we don't lock people up for being weird, creepy. They got to do something first. I mean, it'd be nice if we could look in our crystal ball and lock them up, right? What was that movie years ago where they're like, they know
Minority Report.
Minority Report, go lock them up before the crime was committed.
Exactly. And we can't do that, and we can't force them really for counseling or medications if they haven't actually done anything. I'm sure someone would find that to be violating their civil rights.
You know, about 40 years ago, there were a bunch of lawsuits that said that, you know, we couldn't have the hospitals for the, you know, mentally insane and people with mental illness, you know, so we had to let them out on the streets. And you can only hold them for 72 hours and all those types of things. And, you know, as I get older, and obviously I don't want to lock people up if they haven't done something, but if they obviously have a propensity to harm themselves or others because of some sort of mental illness, you know, it's kind of preventable and everybody knows it. But in today's world, nobody wants to say anything because they don't want to be perceived as being, you know, insensitive, politically correct, so to speak.
Exactly.
But maybe that, you know, all the pendulums always swing, right? First they go, you know, mandatory minimums, hardcore, everybody needs to go to prison, and it swings back the other way. Oh, you're just incarcerating young people based upon their race. That's not fair. You know, give everybody a PR bond, even though they've, you know, committed aggravated robbery, right?
Right. Yeah.
I think people are finally figuring out, hey, that didn't work, right? Made my job easy as a defense attorney. As a member of the community, though, I'm like, oh my gosh, why are we going to let this guy out? Oh my, right?
Yeah.
I mean, I want safe streets. I want to be able to walk my dog or let the lovely Miss Kristen take Miss Winnie the Bulldog for a walk in the park alone and not have to worry about something, right? Everybody wants to be safe. And, you know, all these little tests and evaluations they do, they're like, oh, it's not predictive of this, but well, it kind of is, because we kind of know if you do this by a certain age, you're probably going to do this. And, you know, the old past performance is indicative of future results, as they say. So, you know, sometimes people turn around. People can change if they want to change, but if they don't, they're going to continue to do what they have always done.
Yes. And I appreciate you taking my call. And I don't know if you're aware, but for the first 20 minutes or so of your show, they were not showing the phone number. So I don't know, maybe you didn't get the amount of calls that you normally would. So that could be why. So I just want to let you know that. And
well, thank you.
Appreciate the conversation. You're welcome.
Thank you. Have a wonderful evening.
Thank you.
All right.
Too.
All right, Frank, we got any super chats I missed up here? I don't think so, because we don't ask for super chats, but it does highlight it. But man, that went by fast, and always so much fun. I love taking calls. I really do. You just never know what everyone's going to talk about because everybody has such good questions, right? They're inquisitive. I love it. I love it. You never know. It's like, bring it on. Bring it on. What have you got? What have you got for me? So was there one more call? Yep. All right, we'll do one more call and then we'll call it a night. Hello.
Hi.
Hi, who's this?
This is Lisa Paxton.
All right, Lisa, how are you? What's on your mind?
I am just peachy. Thank you for asking. I hope you're having a wonderful night there. I just have a question about incarcerated individuals' parental rights. I'm looking at Sarah Boone. I've been reading the fact that she's wanting back child support and continued spousal support from her ex-husband and all these wonderful things, because it's Sarah Boone. And I'm not sure I really understand her son's a teenager. So what exactly does she maintain the same parental rights as if she was still walking the planet like normal people?
Yes, kind of. Right. I know. I've had clients that have gone away to prison for a long time. And guess what? If there's a court, like a dependency neglect case where the state has intervened and basically said, hey, we're going to take the kid and put him in foster care or terminate parental rights. If that individual is in custody, they get notice of that. They have a right to appear and say, no, I'm a good person, right? They may not terminate parental rights, but they'll put the kid in foster care. Maybe they'll, because they got to terminate parental rights. And this varies on every state. I don't want to sound like this is my area of expertise because it is not. But technically, just because you may have done some bad things legally doesn't mean that you terminate your parental rights automatically. Now, obviously, who's going to enforce it, right? No, yeah. I told him, the mom wants him to play soccer. Dad wants him to play football. Mom puts him in soccer, right? Well, what's the guy going to do about it? Go to court and say, she's not following my, divorce court?
Well, that's what's really interesting when you read through what all she has submitted that she is, quote unquote, requesting or demanding. She wants 50% time. I'm like, honey, you're in prison.
You're in prison.
She wants 50% accountability by her ex-husband of what the money is being spent on. She still thinks she's entitled to child support for him and she wants any decision to be made, no matter if it's emergent or not, that she'd be consulted because she's so easy to get a hold of. Sure.
She's crazy.
Yes. But she's right. She's always right.
Well, of course she is. I mean, she was convicted of second-degree murder because she put her boyfriend, Jorge Torres, in a suitcase for some sort of weird fantasy role-playing thing or whatever. But she's crazy. What did she go through? 8 attorneys, I think, appellate counsel. She's tried to fire them in every way possible. She's a nut job, okay? And she's got a lifetime sentence of nothing to do. So, she made all the people in relation to her criminal case completely brain dead and crazy by her interactions. So now she's moved on to the civil courts. And eventually the court's going to say, no, Miss Boone, your child is a teenager. What was he, 15, I think?
Yes.
He's old enough. If he'd like, you can call. And if he's there, you can do that. But I'm going to give parental responsibility to dad here. Because let's face it, you're not really in a position to dictate what needs to be done. And if your son would like to see you when he's 18, he knows or he can figure out how to come see you in prison. But I can't imagine that's going to go very far. She's a nut job. Everybody knows she's a nut job. It's all about her. She's a narcissistic sociopath. And she's just one of these people.
One of the things she asked for is that her ex-husband be made to buy presents for her birthday and Christmas from her son. I'm like, what?
She's a nut job. No judge is going to allow that. I mean, who knows? I should never say never. I guess something's always possible, but I think she can ask for the world. She's going to maybe receive a block on a street corner, but she's not going anywhere. She's a nut job. She proved that she's a nut job. it's all about her. And hopefully the best thing that could probably happen to her son is that she not be around him and influence him in any way, because, well, let's face it, she's a crazy nut job.
Yes. Yes, absolutely. Well, before I let you go, I have to tell you, I graduated from law school at Case Western in May, and I sat for my state bar in the end of July.
Congratulations. That's
Thank
a big
you.
a big accomplishment.
I want to practice constitutional law, so there you go.
So you're going to do criminal defense, right? Because that's what criminal defense lawyers do. It's constitutional law.
Well, if that's what it means, yes, absolutely.
All right. Well, congratulations. When do you
All
think
right.
you'll know
Well,
your
thanks for
bar
taking my
results?
call. I will. I
Well,
absolutely will.
okay.
Thank you.
Let us know. See, now back in the old
Thank you.
days when I took the bar exam, I think now they notify people via email, right?
60 to 90 days.
Yeah, via email. When
Yes.
I took
And
the
it
bar
says it'll just
exam,
say pass or fail.
yeah, when I took the bar exam, you had to go down to the Supreme Court building and they posted the results. And it was listed, a list of everybody that passed. So it was like the
Oh,
wall
wow.
of shame. And I remember a guy that I knew in law school. We studied a little bit on the bar exam together, because you kind of study in groups, right? This
Oh, yes.
subject, let's all share notes, right?
Yes.
People still take the Barbary course, I'm assuming, right?
Yes. Yes. Oh, yes.
Anyway, so we go down there for the wall of shame. And of course you're, oh my gosh, this is my whole life. I've just worked 3 years. I, bought, spent all this money on law school, took loans out. I got a wife, I got a kid. Oh my God, I passed. And you're going down, A's, and you're going up, and you go, and you get to R, and you're like, yes, I passed. Yes. And then, I don't know, like a week later, you get something in the mail, and it's like, oh my God, it's really, truly official. But going down there and seeing it, and a buddy of mine we studied, his name wasn't there. His last name began with an S. I'm an R, obviously. So I'm looking, and I go down, okay, there's me. Yes, yes. And, he's standing right there. Oh, it's not there. And it's just the worst feeling in the ever. I'm sure you passed it, though.
I took a lot of practice tests, and I did really well on all the practice tests. And so I'm hoping so, but oh my gosh, it's so nerve-wracking to have to wait. This is a second career for me. I was a trauma nurse for 27 years and left the field to go to law school. So,
well, great. Congratulations.
Second career and ready to go. And, let's go kick some tail tank.
All right. Well, I'm sure you crushed it, and you're going to do great. Congratulations.
Thank you so much.
Let it call back when you pass it. We'll give you a big shout out. What state you're going to practice in?
Unfortunately, Indiana, but that's because I own a dirt race car. We race all over the country in Indiana.
There's a lot of there's a lot of dirt tracks in Indiana. Indiana's near and dear to my heart. I did my type rating in Indiana on my plane. So yeah, I've been there many, many times. So congratulations.
Well,
I know you did great.
I'm a USAC board member, and they are trying to talk me into coming to be on their legal board. And I'm like, no, I race dirt cars for fun. I don't want to be your rule people.
Yeah. Here's what you're going to have to learn. Say no to free legal advice. Okay. You've earned it. Now they got to pay for it. All you've got is your time and your knowledge. They got to pay for it from here on out. Don't do free work. Okay.
I'll just hand them all my student loan bill.
There you go. All right.
Thank
Have
you
a great
again.
night. Congrats.
You too. Bye-bye.
All right, Karen, super chat here before we go. I was wondering if you have any thoughts on Kohberger and Son of Sam. I've read Kohberger's mom is from Brooklyn, like Berkowitz, and of Italian descent in Marianne Kohberger. Any thoughts? I don't think there's any connection, but Kohberger apparently loved serial killers. He studied them. I think he thought he was going to go down in history as the greatest. I think this was round one that he thought he would get get away with it, do it again. And well, he screwed up. He's an amateur. Not only is he a coward to go after 4 young people when 3 of the 4 are asleep, to do it while they're sleeping, what a coward. Seriously. I think he thought he was going to be the greatest. I thought it was going to be, he probably thought it was going to be like some movie thing, the PhD crime guy. What is he? He's like the reverse Dexter, right? Solving crime by day, learning all the little intricacies about it, and then going killing people in the middle of the night. And I bet if he'd gotten away with it, there would be more, and it would be young women. Clearly has women problems, probably, if you know what I mean, right, ladies and gentlemen. He's got issues. All right. Thank you, everyone, for joining us for our live on the Tuesday night. We appreciate it. Have a wonderful night. Check out today's video. Check out tomorrow's video. Check out every video we put up. Make sure that you like and subscribe, right? You know the drill. Subscribe if you haven't. Like if you do. Leave us a comment and hit that little bell for notifications. Have a wonderful night. And remember, the Constitution matters.
All right, lawyer.